Alrighty, these We the People News one more time at it. Educational purposes only. Alright? Anything I say or do is just my opinion, my commentary. Alright? Just take it with a grain of salt. Why? Because I'm not an attorney. That's why. Don't want to dumb myself down any further than I am. Alright, so never look straight forward. Always look around you to be able to protect yourself by any means necessary. Arm yourself with knowledge. Use that Second Amendment. Okay? Anything is self-protection. Even in writing, you're still protecting yourself. You armed with knowledge. Okay? And it's used as a weapon of defense. Alright, let's go ahead and get this started. See if we can end this last one here of this alleged lawsuit on judges. Alright. There's going to be some videos going to be coming up of probably 3 of my favorite court cases. Alright.
Intent or at best was negligent as to his or her duty pursuant. Okay. Denial of procedural due process. The failure on the part of the defendant to perform a duty he was statutorily commanded to perform had the effect of denying plaintiff the full and free access to and enjoyment of the due course of the laws of the state of Texas in criminal violation of Penal Code 39.03 Supra. Said violation was the proximate cause of plaintiff's injury. The Texas Supreme Court has determined that the procedural due process protections provided under the Texas Constitution mirror those provided under the federal Constitution. While the Texas Constitution is textually different in that it refers to due course rather than due process, we regard these terms as without meaningful distinction. Although Texas state courts are not bound by federal due process jurisprudence, we have traditionally followed contemporary federal due process interpretations of procedural due process issues. Now, what they actually do is when they find a federal ruling that they like because it allows them to override a provision of the Texas Constitution by following the federal version instead of the state-required version, they'll adopt it without question. One of those rulings has to do with the assistance of counsel. See, there's a United States Supreme Court ruling that says that assistance of counsel only applies in cases where you can be sentenced to jail as part of the punishment. The Texas Constitution, even though the federal Constitution says no such thing, that's how the federal courts have ruled the interpretation at the federal level. Well, the Texas Constitution specifically says that you have the right to counsel in all criminal prosecutions, period. Doesn't differentiate between whether or not you can be sentenced to jail. It just says criminal prosecutions. That's what they're bound by, but they didn't follow it. Instead, they went with the federal ruling, and now that's why you don't get a fucking lawyer for Class C fine onlys, because they cannot sentence you to jail for them. Now, let's not even talk about the fact that they put you in jail for many of them after they arrest you for them. There's no lawyer to get you bailed out. There's no lawyer to make your first appearance. There's no lawyer to do a lot of things for you, including your initial probable cause determination hearing. No lawyer for any of that, even though they're required to provide one. So don't believe this bullshit from the Texas courts, because they're full of fucking shit. Importantly, Texas courts interpreting procedural due process claims.
And I'm going to step a little further up because just a few videos back, we talked about how the state says it's federal under their definition, right? So, it is wrong and right. So we got to make sure when we go to court, we got to have that clear distinction. Is this a Texas constitutional court, or is this a federal constitutional court under the guides of the state by their definition? You guys figure out how to word it the best you want to.
Applied the Matthews factors to determine whether due course of law is provided under the Texas Constitution. Again, no they don't. Breach of contract. Defendant swore on his or her oath that he or she would uphold the laws of the state of Texas and protect the Constitution in contravention to defendant's sworn oath. Again, that's a contradiction, Randy. Sworn oath in contravention of his oath. What the fuck? Defendant swore on his or her oath, blah, 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 protect the Constitution. Defendant then proceeded to fail or refuse to perform a known non-discretionary legal duty in contravention to defendant's sworn oath. After defendant swearing on his or her oath, defendant received compensation from state funds. A contract is not a contract until something of value changes hands, and in the instant case, defendant collected payment from the state for services rendered, creating a contract. Generally, the term contract refers to an agreement between two or more persons that creates an obligation to do or not do a particular thing. A contract is recognized as an agreement between two or more persons, blah, 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 blah. In the instant case, defendant agreed to uphold the laws of the state of Texas and protect the Constitution by the swearing to his or her oath of office. Express contract. The covenants of the above contract are expressed as they are contained in the Constitution and the laws of the state of Texas. Defendant has sworn to uphold as a condition of employment. Okay. In the case of Walmart versus Lopez, and why is there... Courts ruled as follows. An implied in-fact contract arises from the acts and conduct of the parties, it being implied from the facts and circumstances that there is a mutual intention to contract. Why would Randy not find case law dealing with obligations of public officials upon the taking of their oath? There has to be case law that says the official had an official or contractual or constitutional duty to perform these things in compliance with their oath. There has to be case law for that somewhere. So why is he going only after corporate bullshit is my question. A meeting of the minds is an essential element of the implied in-fact contract. Texas Association of Counties, blah, blah, blah. And in an express contract, mutual agreement is expressly stated. In an implied contract, mutual agreement must be inferred from the circumstances of the transaction. The court must look to the conduct of the parties to determine the terms of the contract on which the minds of the parties met. The conduct and circumstances surrounding the transaction are to be viewed from a reasonable person's interpretation at that particular point in time. Third-party beneficiary. In the Restatement of Contracts, 2nd edition, the concept of third-party beneficiary is addressed as follows. A third-party beneficiary contract arises when two parties enter into an agreement for the benefit of a third person. Traditionally, the requirement of privity prevented the third party from enforcing a contract to which he was not a party. Gradually, courts eroded this requirement, in some cases allowed third parties to enforce agreements made for their benefit. The first Restatement of Contracts fostered this development and sounded the death knell for the privity requirement by formally recognizing that certain third parties had independent rights in some contracts. Here we anticipate a claim of judicial immunity. Judicial immunity was never contemplated by the Texas legislature, and there is no Texas statutes which address immunity. The term immunity only occurs in two local rules in Henderson County. Otherwise, the word does not appear in Texas law. Officials routinely cite Texas Civil Practice and Remedies Code 1.04001, which reads in pertinent part as follows.
So keep that in mind as well. Immunity. As long as you keep it in the state, and you bring suit, right? Your officers, right? Now, it can be upgraded into, but as C.J. Grisham says, as long as you keep it in common law as well, if you sue just the officer, it disposes of what is that case? You guys look it up, but Manel case, something like that, right? Then the city or the county would come back in and say, hey, no, we're going to back up our officers. Well, you don't have to use and contest the Manel to keep proceeding forward on the immunity. What you would do is say, hey, Texas don't have it, right? And I didn't sue the county and the officer or the city and the officer. I just sued the officer. Why? Because Texas don't have immunity. And use that case of 1871 Act. Keep it in common. Hell, I don't even say either common law is 1871. But by this, it don't even say it has to be common law. You can just sue them, right? And when it goes into they want the immunity in federal court, no, I want this in where there's no immunity. I didn't use the Manel. So the Manel is null and void in this case. I'm not bringing in the city or the county. They're volunteering themselves into it.
Liability persons covered. In a cause of action based on conduct described in section 1.04.02 or 104.002, the state shall identify the following persons without regard to whether the persons perform their services for compensation for actual damages, court costs, and attorney's fees adjudged against. See, that's the other thing that Texas courts have adopted that doesn't exist in Texas is qualified immunity. Qualified immunity does not exist in Texas in any constitutional form and any legal form. It is something they adopted from the federal courts, despite the fact that the Texas Constitution and Texas state laws specifically authorize actions against public officials for abusing their offices, criminal conduct, and all these other violations of rights they commit. Texas law specifically authorizes all of it. And yet, the courts protect them with qualified immunity from the federal level. So you see, they take federal jurisprudence when it suits them, and only when it suits them. And they ignore the state constitution and state law if they can use the federal stuff as a crutch to say that's why we're not using it, and get people to believe that that's a valid argument. It is the assertion and allegation of plaintiff that defendant perpetrated an anticipatory breach of his or her contract with the state wherein defendant swore on his or her, again, I'm going to assume he meant his or her oath, to perform an administrative duty she or he was commanded to perform under Texas Code of Criminal Procedure 15.09 Supra. Said duty is a duty over which defendant had no discretion and thereby failed to act in accordance with the above referenced employment contract with the state. Again, what are we defining as state? Defendant, by failing to act in accordance with his or her sworn oath, repudiated his or her contract with the state and acted in his or her personal capacity by refusing to perform the duty prescribed.
Yeah, and that's going to be another thing you want to bring up in your case if you sue. That you're going to be the state. You are bringing in suit being the state of the people, not their definition of the state of the federal government. All right, so we got to be particular on that, I believe. Okay, I'm not an attorney, not giving legal advice, educational purposes only. Okay, it's my commentary, no more, no less. But it's an idea because we don't look straightforward. We always look around us, be able to protect ourselves by any means necessary.
By Texas Code of Criminal Procedure 15.09 Supra. By doing so, defendant denied plaintiff in the equal protection of the laws of the state of Texas, rendering plaintiff a crime victim by the hand of defendant. Defendant, in the instant case, by refusing to perform a statutory duty over which defendant had no discretion, repudiated his contract with the state and subjected himself to quo warranto removal from office under Texas Civil Practice and Remedies Code 66.012, which reads as follows. 66.001 grounds. Again, Randy, what the fuck, man? Is it 001 or 01? 001. An action in the nature of quo warranto is available if 2, a public officer does not act or allows an act that by law causes the forfeiture of his office. Prayer. Plaintiff moves the court to order defendant to pay the plaintiff damages in the amount of $19,000. There, Randy. Since the legal limit is $20,000, according to the way they've got the codes written, but it violates the way the Constitution has it written. Somebody, real quick, tell me how much money the Justice of the Peace Court has jurisdiction over in a civil case.
All right, let's skip that up because I don't want to keep this short. We're going to bring it up here in a second. Okay. So, here in Texas, it's $200. Internet slow. So if you think you're going to bring a small claims court of up to $20,000, that would be an unconstitutional claim. Okay? You have to go into a higher, for the GP.
Jurisdiction of Justice of the Peace Courts. Justice of the Peace Court shall have original jurisdiction in criminal matters of misdemeanor cases punishable with fine only, exclusive jurisdiction in civil matters where the amount in controversy is $200 or less, and such other jurisdiction as may be provided by law.
So which statute is telling them that it's $20,000? Because
what did you just read?
It doesn't give me a statute number or anything.
Well, see, here's the problem. The statute they're attempting to use to increase the $200 is now in conflict with this section of the Constitution, because this says other jurisdictions, not and this value may be changed by law. The $200 cannot be changed by law. That's a jurisdiction set by the Texas Constitution. The clause they're trying to use to change it is "and such other jurisdiction as may be provided by law." Well, they can't use a law to change a jurisdiction that the Constitution says is fixed. So they can't change the 200 to 20,000. Can't do it.
God's fault. So if you are sick, it is your fault. It is your lack of faith. It is your unconfessed sin. It is your lack of giving
well,
enough.
Hallelujah, brother, and all that shit. Who's praying on the damn airways while we're having a class here?
It's your fault. Maybe you're not even saved.
Okay.
And there we go. All right. Now, that being said, they can change it and do a constitutional amendment and then add to it and change it. But they have to go through the due course, and they have to ask our consent to vote on it to change it. Okay? This is We the People News. Bye, y'all.